Hello, everyone, and thank you for joining us for today's webinar, where we will be talking about excluded property. If you're listening to a webinar on excluded property, I'm assuming you have an understanding that, we're talking about property division in the event of a separation and just talking about net family property calculation. So hopefully Anisa would touch on that a little bit for us, but I'm guessing that you have an idea of that and you just want to know what properties you can exclude from equalization of your net family properties. You have a great speaker with us today. For those of you who don't know Anisa Dattu, she's fantastic. Anisa has been practicing in family law for many, many years now, started as an intern, an articling student, law student, called to the bar. So she's worked in every area in the family law realm. Anisa, she's been at Anisa, you've been at the OCJ, you've been at the Ontario Court of Justice, the Superior Court, and you've also appealed final, family court decisions. So Anisa comes with a lot of experience. And Anisa does a lot of volunteering over her time as well. And even with us here, it's very confounding. We don't know where Anisa finds the time, but it's just a testament to her desire to help people. Anisa volunteers. I'm just going to mention two of many places, but one is some of the dearest to her heart is like Luke's Place, where she helps women that are living abusive relationships with legal and family supports to some extent. So that's, she gets to give her wealth of experience, volunteers her wealth of experience to people who need it. And Anisa also grooms the future generation. She does a lot of coaching through Future Possibility Kids. It's an organization she was a part of, and she swears by them to making her become the person she is. She's a leader at our firm, and she wants to empower, youth from diverse communities and things like that to, be able to think possibilities really. So Anisa, I'm going to let you dive right in. And I think for just in terms of general housekeeping, there's, depending on what kind of screen you have, if you're on a desktop, it would probably be at the bottom. I know phones are kind of set up differently, but somewhere if you hover around your screen, there should be an option for a chat, so that if you want to type in a message and I can have Anisa sort of maybe interrupt whenever, or would go over them at the end as appropriate. So without further ado, Anisa Dattu, it's on you.
Thanks so much, Angela. Thank you for that wonderful intro. And as you mentioned, I will be talking about excluded property under the Family Law Act. And kind of just a disclaimer, it's not an easy topic. It's really not an easy topic, which is why there's so much research, there's so much case law, the case law is evolving, and sometimes we just don't have clear answers. For the most part, with an area like this, it's really important for you to get your own independent legal advice, to sit down with a lawyer, go over things, because we'll talk about some cases that I find particularly very interesting and that have also made precedent. But you'll see kind of how things can be going your way, and then all of a sudden, wait a second, it's not, and that's just the law of excluded property. So I have a lot of information that I want to get through, and I know sometimes, I'll try to keep it as basic as possible, so that it's not kind of too complicated, because like I said, this area can get complicated. But the general intent, as most of us know, for married spouses, okay, the general intent of the Family Law Act regarding the division of property owned by married spouses is to equalize the increase, okay, of net worth that's owned from the date of marriage to date of separation. So why I want to explain this to you is because when we're dealing with equalization, that's where the issue of excluded property arises, okay? So that's where it arises from. And what the most important thing is to know is that these properties can be excluded from an overall calculation. So for example, let's say spouse number one has a net worth that's increased by 200,000. Spouse number two has a net worth that's increased by 100,000. The general equalization calculation that we'll be making, that we'll be calculating, would be a payment of $50,000 from the higher spouse to the lower spouse, okay? But now let's say that there was excluded property. That could actually skew the calculation and go the other way. Okay, so there are exceptions to this rule, and the exceptions are that when married couples have to separate and divide their property, Section 4.2 of the Family Law Act excludes the following categories from this calculation. Okay, so remember, these are categories, so they're not particular assets or anything. These are categories that Section 4.2 is excluding, and it's vague for a reason. Okay, because it's open for case-by-case basis for a lot of situations, as best as possible, of course. So property other than the matrimonial home that was acquired by a gift or inheritance, that's really important, from a third party after the date of marriage. Okay, so that's one of the first categories. The second category relates to the first one, and that's income from those properties that was acquired by gift or inheritance. The third one is what a lot of people don't know, and those are damages or the right to damages from a personal injury claim, nervous shock, mental distress, loss of guidance, care, companionship, or a settlement or part of the settlement that reflects that. Okay, again, very important, and I will elaborate on that more. The fourth category is proceeds or right to proceeds of a life insurance policy that's being received. That's defined under the Insurance Act. Okay, so it has to be a legitimate life insurance policy. The fifth one is property other than a matrimonial home. Okay, so I talked about this before. There's the category that's, property other than a matrimonial home that was acquired by way of a gift or inheritance. But here, it's property other than a matrimonial home where any of perhaps the gift, inheritance, or personal injury settlement that can be traced into. Okay, so it just can't be a matrimonial home. It has to be other property, separate and apart. Or the easy ones, property that spouses have agreed by way of a domestic contract, marriage contract, prenup, that is not supposed to be included in the net family property calculation upon a separation. And then the last one is any unadjusted pensionable earnings under the Canada Pension Plan, so your CPP. I want to focus on a few, and the ones that come up to us very often, and those are property that's commingled with the matrimonial home, joint property that deals with gift or inheritances and income that arises from it, insurance settlements, and the marriage contract. The marriage contract's really easy. If you're planning on getting married, or even if you're married right now, you can also do one after the date of marriage, but you need to decide, you need to sit down with your spouse and have a conversation as to what will be excluded. If there will be a separation, it's going to make things a lot easier to know what we agree to, what will be excluded. It'll save you a lot of time and stress in the long term. But that's one of the main aspects of a marriage contract or a prenup that we deal with. A lot of the times when people come to us, they say, I have a business that I want to exclude, or I have an inheritance that I received perhaps before the date of marriage, or a gift, or my mother wants to give me the down payment of the matrimonial home. What does that mean for me? Okay, so it's really important to, if you're thinking of getting married, or if you're already married, to think about doing a marriage contract if you don't have one. But with these categories and some of the issues, I mentioned matrimonial home a lot and protecting gifts towards a matrimonial home at the time of a separation or a divorce. And, gifts and inheritances, it's a really, it's a very interesting area of law to me, because gifts or inheritances that are received during the marriage generally are excluded property if they're received from third parties, right? Easy enough, but it's not so clear cut. Again, it's, this isn't the case if the gift or inheritance was put into the matrimonial home. So a lot of people think, hey, my mom's gifting me $100,000. I'm going to pay off that mortgage that we're making a high payment for. Let's get some of the interest down. Let's make it easier for us. And then conveniently at the time of separation, well, my mom gave me $100,000 and that should be excluded, right? Because that was for me in my life. So I don't have to pay such a hefty mortgage. But the matrimonial home is treated very separately and very differently from other property in marriages. And unfortunately, if any excluded property is commingled and is put into the matrimonial home, unfortunately, that exemption is lost. So a lot of people don't know this, and there still is a high rising number of cases, because obviously case by case basis, right? Not all cases are going to be the same, but the general rule, the general presumption is keep your property separate. If you have excluded property, keep it separate. Don't commingle it into the matrimonial home, because Section 4.2 of the Family Law Act indicates that the value of the matrimonial home and any gift toward the matrimonial home made during the marriage is equally divided between two spouses in the event of a separation. So it's very clear, and it's very easy for lawyers to rely on that. And it's very easy for judges to rely on that as well. And the judges aren't, they're not shy from hearing the claim of this was a gift during the marriage, but all of a sudden it's become a loan post-separation. So a lot of people then say, well, we'll go back to our example of the $100,000. Well, you know, my mom had given me $100,000 to help pay off that hefty mortgage during the marriage, but I need to pay it back to her. So it really wasn't a gift. So there's so many circumstances. That's when it gets really interesting. There's so many circumstances that we look at as to whether it was a gift, whether it was a loan, and what do we do about that. So to determine whether there's a gift or a loan, you know, a court would consider factors such as whether there was any documents evidencing a loan, whether there was a contract or anything like that. Was your spouse aware of it? Is really, really important. Whether there's a manner for repayment specified. So have you guys talked about repayment terms? Maybe when we sell the house, you'll get your 100,000 back or something like that. You know, is there any security held for the loan? All of these things need to be contemplated if you truly are getting a loan and if you don't want it to be seen as a gift that's been commingled into the matrimonial home. The court will also look at specifically if it's a gift, which is common from parents to their children, whether there are advances to only one child or to multiple children. Maybe they've retired and they realize, okay, I have 300,000 and I have 3 kids. So I'm going to give each of them 100,000 towards their life, and they can do whatever they want with it. That's a gift. And whether there has been any demand for payment. So have your parents come, or has the gifter or the testator asked you for, sorry, the gifter, have they asked you for repayment of that? Or any partial repayment, right? Have you actually tried to repay this loan? You just couldn't afford it. Or any expectation of a likelihood of repayment. If you cannot meet any of those criteria, then a court will see it as a gift. It's very, very hard because, like I said, the court's not shy from seeing that argument of I received a lot of money during the marriage, but conveniently it's a gift post-separation. The other spouse is none the wiser. So it's a hard argument to raise in court.
So, you know, something else I've found as well, there's times when I mean, like, especially when we're dealing with our clients, or maybe the parent approaches us to, you know, maybe they're being added as a party and now we have to help them. I find it in some cases, it's genuinely a loan. So I think people just need to be intentional is the word I want to use. And I know I borrow that term from like yoga and things like that, but we really need to be intentional because sometimes it's really meant to be a loan, not a gift. And it's, you know, was put into the matrimonial home. The person wasn't ready to give a gift at that time, but because, you know, it's your child, it's, you know, you're looking at both parties, your child and your partner as your children, right? And you're just kind of lax about it. So a lot of times just get some kind of documented paperwork. If, you know, and there's ways around it. Again, as Anisa, you had said earlier, talk to us, because even if you don't want a payment plan, if that's part of the plan for helping a child, then you want to make sure it's documented, because as Anisa said, the lack of payment or payment plan can all of a sudden turn your loan into a gift that's now in a matrimonial home that you can never exclude, right? So just being intentional about things that you do, no matter the nature of the relationship, I think is pretty important.
Oh, absolutely. Thanks for mentioning that, Angela. Absolutely. Being intentional about what's happening, especially when it comes to your matrimonial home, is essentially paramount when it comes to this category. And a lot of parents don't understand that either. They think that the children are going to take care of this and that they understand what's happening. So for a lot of parents who want to be very generous and perhaps either gift or loan money to their children, or aunts, uncles, grandparents, guardians, you know, it's very important to have that intention and to have a conversation. It doesn't have to be your child, your grandchild, your niece, godchild who needs to have that conversation with the lawyer. You can as well, being the gifter. Okay, so that's really important to know, because it's also what is your intention. So moving on to the next issue, which relates to the matrimonial home, but basically it's gift and inheritances that has been commingled with other property, not the matrimonial home, but with other property. And what's interesting about this is, let's say you received a gift during your marriage of $25,000, and let's say you received a check of $25,000. It was a gift to you for maybe your 50th birthday, and that money was deposited into your joint bank account with your spouse, and then maybe it was transferred out. But what happened there, right? Why was it, if the money was a gift to you and solely for you to use, you should keep it separate and apart. So it's a good idea to put it into your own bank account, open up your own bank account. We see a lot of spouses who don't have separate bank accounts. For whatever reason, a lot of them believe that it's taboo to have separate bank accounts. We're not trying to hide anything. But if you do want to keep that intention of, this is money for me, I'm not trying to share this with my spouse, then you want to keep the money separate and apart. This actually happened in an Ontario Court of Appeal case, Cortina and Cortina in 2015, where the husband and wife were involved in a dispute over custody, access, child support, and equalization, okay? So the trial judge actually ordered that certain property is excluded from the husband's net family property for the purpose of calculating equalization on the basis that it fit within the definition of excluded property under section sub 2 of, section 4 sub 2 of the Family Law Act, okay? But the husband had the onus of proving the deduction, that it was excluded property under the net family property, okay? So in this case, you know, the issue, it went to appeal because the issue was, well, what happened to the money? The husband in this case was holding about $122,000 in an investment account. The funds had been given to the husband's mother. We see this a lot, okay? The issue on appeal was whether they were proper, whether this was properly excluded. So the exclusion could have been, it could have been excluded property, but was it properly excluded? And does it still fall under the exclusion from the husband's net family property, which would disentitle the wife from receiving any share of that? So the money was deposited into a joint bank account first, and then was transferred into the husband's investment bank account. And it continued to grow for about 5 years prior to separation. This begged the issue of what we see a lot, which is tracing. Okay, so we see a lot of tracing in family law, and tracing means we have to now kind of do that accounting of seeing, okay, so the money was here, then how much was transferred out into this account. So we're literally following, we're tracing the funds, okay? Section 14 of the Family Law Act states that the fact that property is held in the name of spouses as joint tenants is proof in absence of the contrary. So let's say you don't have proof that the funds were a gift. The fact that it was held jointly in a bank account for some time is proof that it was meant as joint funds for the family, for the couple, okay? And that they intend to own the property together, or that maybe, you know, the husband was gifted the money, but he intended to share it with his wife. So do you see how it can sometimes jump and you lose the exclusion? So basically, tracing was warranted for this, and you know, obviously the wife in her appeal argued that the money was intended to be a gift to both parties. Okay, the Court of Appeal noted that there was ample evidence to support the finding that that the husband's mother intended that the money was to go to the husband alone. So again, case by case basis. I'm not going to go into it for the purposes of today's webinar, but you know, it was hard for the Court of Appeal to grapple with this issue and with the tracing issue. Okay. The Court of Appeal did accept that the trial court's finding that there was sufficient evidence to rebut the presumption that the property held in the name of both parties was intended to be joint. But ultimately, the exclusion was not lost, because what happened in this case, and which doesn't always happen, but what happened in this case was that it was clear to the Court of Appeal that that the husband had essentially kind of parked the money into the joint account before transferring it into his investment account. Okay, so you know, if the husband had left the money in the account and then used it towards the mortgage, paying debts, groceries, bills, things like that, he would have lost the exclusion. The facts in this case and the evidence as well that was provided support that the money actually did fall under the exclusion. But again, that was one case out of so many. So it's really important to like what Angela said, have the intention, know what you're doing. I always tell for a lot of the clients that we have that come to us for marriage contracts or even just advice, and they don't end up doing the marriage contract for whatever reason, or even those spouses that come to us just for advice in the middle of their marriage. Sometimes they just want to get some advice. It's really important to know what you're doing. It's not just you may know that you're parking the funds in a joint bank account because you intend to transfer them out and that's your only bank account that you have. Or for example, you're receiving an inheritance and you're putting your $122,000 of inheritance into a joint bank account. But remember that your spouse has easy access to that account. If they want to withdraw the $122,000 and go buy a property, for example, go put a down payment on a property, they can. They want to go buy a car, they can. On a very expensive shopping spree, they can. All of a sudden, that money is not just yours, it's gifted and they have equal access to it.
Anisa, we had a very difficult case like this at our firm, and I don't know if this would probably jog your memory a little bit. And in that case, the money actually remained in a joint account and our client didn't get a separate account until after the date of separation. That was a very difficult case because she essentially took her funds and put it in the account, and the parties used this account until just right at, about the time of separation. We were able to successfully argue that that the inheritance should be excluded, but it was not an easy task. It was very difficult, and I just, don't put yourself in that situation if you can. Just don't.
Yeah, it was a lot of paperwork and a very high legal bill.
Yes.
Kind of counteracts the money you're trying to save, right? We're not trying to increase your legal bill by doing tracing it. It's hard on us as well. But it's something that can be done and to kind of save that money that you received. And a lot of it for a lot of our clients, it's also the principle of the matter. It is possible to trace, not 100% effectively sometimes, because sometimes if the money's left in a joint bank account, you have to remember that if that bank account is being used by both spouses, and then on top of that, let's say both your incomes are going into that account, it is very, very difficult to trace what happened to the money. Was the gifted or the inherited money actually used towards that grocery bill or the gas bill or property tax or the mortgage? It's really difficult. So it's very important to keep your property separate and apart, because you can lose that excluded property exemption if you cannot prove it.
Anisa, can I jump in here and say something? Because I know when we say this, for people that are not going through separations, it almost looks like we're trying to break the family unit. And I've had friends that want to keep certain properties, not because they just, not really just for the purpose of just equalizing it, but because they and their husbands understand that this inheritance is your retirement plan. Or someone could own a home, and between yourself and your partner, that, okay, he or she has, a government pension. I want to keep this property separate for myself. I've inherited this money. This is our retirement plan. And it's still part of the family, but you want it to be your own contribution to the family at retirement, while the other person has a separate plan. So it's not really about being diabolical or sneaking behind the person's back. It's just that was your intention, and it would just be very unfortunate if at the time of separation you can't get to exclude, you can't get to leave out the intention that you and the other party both knew about, because now all of a sudden they're denying it, right?
That's a good point. That's definitely a good point, because you're right. If you're receiving a large gift or inheritance, we're talking more than it's not just $100 that you receive as a gift on your birthday. We're talking thousands of dollars for a lot of people. You're not trying to be diabolical. We're not trying to encourage that. And it is a hard conversation to have sometimes, but it's the reality of it. And your intention is very important. You can use the funds. You can still keep it separate and apart. And you have to just be careful on how you have used the funds. And it's very important to know that if you do have the intention to maybe want to keep it separate and apart, to not put those funds into the matrimonial home as well, like I had said. Because, even if you have the intention to eventually want to put it towards the home and pay for those expenses for your family, then you won't get that back. You won't get that back. There's one case that in a 2010 case that is still very relevant today. It's called Townshend and Townshend. The husband here received a gift of, it was $25,000. Now, keep in mind, 2010, $25,000, a lot of money during the marriage, okay? The wife, again, deposited the funds into a joint account. On separation, the husband wanted to exclude this money as a gift, and his wife opposed the exclusion. She said that the money was gifted to both of us. So all in all, in the end, of course, the husband had to prove that the money was a gift, and he had a very, very hard time doing so. So in this case, what was really interesting is that the court here had basically found that excluded property that's deposited into a joint account that both parties have, both spouses have access to, loses its exclusionary character to being excluded property under the Family Law Act, except for 1/2 interest that is presumed to be a gift. So basically, instead of getting the full value, the husband was able to recover 1/2 of a half. So basically 1/4 is what he was, sorry, 1/2 is what he was able to get. So basically not 25.
No, but you're right, Anisa, because when you put it on when you excluded the effect is kind of a quarter that he doesn't get to share per se. So I kind of get where you were going there with the quarter.
Sorry, when it comes to numbers, it definitely does get a little confusing when we're talking with big amounts. But what I'm trying to say is he was able to recover a little bit of it, and that was specific to this case. That's not all cases, but in this case, what is true for a lot of families out there is that the money stayed in a joint bank account until separation. So again, tracing that money, like the case that we had that Angela mentioned before, it's not an easy job, but he was able to do it up until that extent because he was able to prove that it was a gift. But obviously, wife said that the money was a gift to both. Husband saying that the money was just a gift to me. The judge kind of got them to essentially settle in the middle. Okay, so that's really important. The other case that's related to this that I want to mention before I move on from this topic is basically the case of it's butter and butter, or booter and booter. I'm not sure if I but this is, I believe, a 2013 case. And what's important about this case, I'm not going to get into the details, but what's important about this case is this case really highlighted what is a gift. And why I want to mention that is because gifts, like I said, gifts can sometimes change form. Sometimes they're a gift, but they can become a loan or something like that, or it was never a gift to begin with. And spouses sometimes see different things in what the gift is and what the intention is. So in this case, the court really focused on, well, what is a gift? Because here, the gift, was there consideration given for the gift? In this case, we're talking about farmers with kind of a milk quota. So it's not an easy case if you're not familiar with the farming industry, which is why I don't want to get into the details, but the court looked at, well, the parents were gifting their milk quota, which I believe was worth about $400,000 to the son. But was there consideration for it? And the court found that there was some consideration for it. It might not have been directly money given, but there was some consideration for it. And part of that was actually a tax exemption as well. So it's really important that it doesn't have to be money that you're giving as a consideration. It can be kind of a quid pro quo. It can be a service that you're providing to the gifter. It can be a variety of things that really, you want to tell your lawyer everything, because they're going to be the ones that they're going to be able to kind of see through it and see, oh, does that sound like consideration? Does that not? Does this actually mean a true gift or doesn't it? Okay. And so that's really important that for you to know. And so I want to move on from that one. And I want to talk about insurance settlements, because this one's really important. Because a lot of people ask me, Anisa, will my personal injury settlement affect my family law separation or my divorce? And the easy answer to that is yes, it definitely will, because we can either exclude it or we can't exclude it. And when a personal injury matter settles, there are two primary ways that the settlement can be paid out to an adult claimant. And that is either a lump sum cash payment, so a lump sum, or a structured settlement. So structured settlement meaning periodic payments. And a personal injury settlement can have an impact upon a family law situation. And it's a good idea to receive advice from us on this, because there's still uncertainty in Ontario as to how the various heads of damages can be treated when calculating your net family property. The general presumption is that if you are receiving a lump sum settlement, and if it's related to something that's impacting you, that there are damages that's impacting you from getting an income or future income or current income, then generally that lump sum settlement will be excluded. And there is case law to support that. Court of Appeal decisions. One of them is Hunks and Hunks, a 2017 Ontario Court of Appeal case, where we can reasonably be certain that a structured settlement meant to replace the recipient's future lost income is going to be treated as income and not be included in the calculation of someone's net family property. So what that means is the two different treatments. So if it's a lump sum settlement, generally we can rely on the fact that the lump sum will be excluded as long as it's a lump sum for damages that's affecting pain and suffering, things like that. But if it's a structured settlement, now what's going to happen? Because you don't really have all that money up front. So for a structured settlement, that can also be excluded from net family property calculations, but it'll be seen as income for a whole nother issue, for support issues maybe. So, but that's another topic that that we should really do another webinar on, so that you're more aware of that. But generally, the situation isn't as clear here. And like I said, there still is some uncertainty. So it is really important that a lot of people don't know that when you do have a personal injury settlement, that sometimes it can be excluded or it can't, and how that plays a role. Sometimes in personal injury settlements as well, your spouse gets some money for their own pain and suffering, or their own effects of what the damages are. And it's important to look at, can that be excluded or not? Lastly, the big thing with excluded property is to know that tracing or proving it is very important. So it's really important to understand that you will have the burden of providing documentary evidence, whether that is getting documents that show intention, whether that is finding the gifter or finding the will that gives you the inheritance, or that gives you the gift, or the documents that show down to the last cent what you received. It's really important. It's generally a really good tip is to keep your property separate. Keep it separate. You can do what you want with it, but keep it separate. And always remember that if you're going to put money into the matrimonial home, that you will lose that exemption. If you're going to commingle your property with your spouse's property, you will lose that, or you can lose that exemption. And it's very clear if you're putting that into the matrimonial home. And it's important to have a conversation with a lawyer, with an experienced family law lawyer, to know if any of this applies to you right now, even while you're married, because there are things that you can do about it. It is harder after separation, because obviously you and your spouse are not on the same page anymore. And it might not be amicable, and that can make the difference between perhaps a $5,000 legal bill to a $200,000 legal bill sometimes.
Absolutely. And so there's something I want to add here, and you can touch on this a little bit, and I know it's going to be a bit technical, but sometimes when we're doing the net family property calculations, people often wonder what the difference is between a date of marriage deduction and excluded property. So both have the effect of reducing your net family property and how much you're required to equalize with your partner. But with the date of marriage, and it could be very interesting when, say, you've had your inheritance or whatever before the date of marriage, or just even being strategic and trying to choose how to do things. So to keep it simple, the date of marriage, for a date of marriage deduction, all you need to show is that you own the property on the date of marriage. You no longer need to own it as of today. However, with excluded property, it's the amount that you own as of the date of separation that counts. So even if you inherited $1 million, you put it in a separate account and you spent it on the family or however it went, you don't get to exclude $1 million. If only $100,000 is left as of the date of separation, you only get to, if on the date of separation, you have $100,000 that can be properly traced to be excluded, to be a gift or inheritance, $100,000 is all you get. However, if you came into the marriage with $1 million home, which has subsequently been sold during the marriage and no longer exists today, you can still get that date of marriage deduction. So that's something that I'm often asked, how do we pick and choose? And I know another one, people sometimes who had inheritances and all of that before the date of marriage also wonder, is this a date of marriage deduction, or is it excluded property? For it to be excluded property that Anisa is talking about in this context under Section 4 sub 2 of the Family Law Act, it has to be gift or inheritance that you acquired after the date of marriage. So I don't know if you want to weigh in on those, Anisa. So it's, I had mentioned about it doesn't have to be owned if it's a date of marriage deduction. And if it's to be excluded, you literally have to have received that gift or all of that stuff after the date of marriage.
Yeah, basically, yeah, that's a good point, Angela. Yeah, there is a confusion around what excluded property is and what date of marriage deductions are. And it's true that if you, for example, receive the gift or the inheritance before your date of marriage, then you don't get to classify it as excluded property, because excluded property applies to anything that was received that can fall under one of those headings or those categories after the date of marriage. And it's true, you can, if you received $1 million, you can't deduct $1 million towards the end. You have to prove that the $1 million is still existing. So it's not like a date of marriage property or asset that you have. And it's important to, if you're going through a family law matter right now, or if you're just curious, I highly encourage you to pull up one of the Ontario rules, Ontario Family Law Rules court forms, specifically Form 13.1. Take a look at it. There is a section there for excluded property, and it's a way that you can exclude it from your overall net family property calculation. And if you are receiving financial statements, you're in the middle of a family law matter right now, pay attention to that box, because a lot of the time it's overlooked or something. Pay attention to that box, to that section, and see how much is being excluded, because that's all very important. If you are, remember what I talked about marriage contracts before, the prenups, that's a way to help protect anything that you receive before the date of marriage that you don't want to lose during the marriage as well. So it's something to definitely put your mind to.
Exactly. Okay, wow, Anisa, you really shared. It's amazing how you were able to compact all of that information into a short amount of time. I don't see any questions on the chat right now. So I honestly, from my perspective, I think you really covered it all. So without there being any question, I guess we can call this a wrap.
Excuse me. Hi, this is Mona.
Oh, hi, Mona.
I'm sorry, I didn't know that I should send you a question, but I have two questions. Do you have time to help me?
Oh yeah, absolutely. Absolutely.
Okay.
Go ahead.
First, when she talked about injury, I'm in divorce process now. Okay. And there is two things. I'm concerned about it, and you mentioned it now. Thank you so very much. You've been very helpful to me. First of all, when you talk about injury, I had an accident before the separation time, car accident. And this was like really huge accident. And they rushed me to the hospital, airbag blow off. Like it's really bad, And I have been suffering since 2017 up to date. With many illnesses and the insurance company did not give me any money as a settlement or any money buckets, just only they give me an income replacement for a very minimum amount. It's like almost $600 a month. And then the settlement is not happening, and they still pay me for my medical, and all goes to the company. It's not like to me. Like I have RSW, I have BSW, and all goes to them. It's not to me. But the respondent claimed to the one of our case conference that he need the entire file for my car accident. And then my lawyer accident sent a letter to the court saying that I don't have any settlement. I didn't get any cash back. I didn't get any money back. And my file only has the medical and medical documents, and we can't share it because it's confidential. But the respondent still insists that he needs. So I sent to the court the disclosure that judge asked me for many things, like for my government income, for my pension, like many things. And I send it all to them. I did get back the answer yet, but it's clear that I didn't take any money. I'm still spending the money the insurance is going to give me for my illnesses, and I don't know how long it's going to take. I'm going to the fourth year, like in fourth year now, almost in July, I will be fourth year in disability, right? Through my government, sorry if I'm talking too much, but it's really important. Thank you so very much. For my government, actually, I was working in the Ministry of Citizenship and Immigration. And then at that time, when I get injured, they give me 6 months short-term disability. After that, they approved with no questions about long-term disability. And I have been long-term disability since January 2018. Up to date. And they always send me a letter say like I'm not entitled to go back to work because my medical report shows like I'm not able to fit in any job.
I'm wondering, Mona, give me 1 second, because what I'm wondering here, there's two issues that I'm kind of picking up here. I'm hearing income and support issues, and there's also property issues. Honestly, and Anisa, please weigh in on this. If it's just from a property perspective, the simple answer is all the things they're asking you for doesn't matter, because whether you got the damages before the date of separation or after, or where things are, and it doesn't matter. Your short answer to them should be, it's none of your business, because it's going to be excluded anyway. So why would you be putting me through the hoops to get you documents showing how much damages I've received or not, when really it's excluded property? So it's that simple, but they may be asking you for all of this information. Sounds to me like it may be going to the issue of support. Anisa, what do you think?
Yeah, I did support, I did, and he refused to give any disclosure. Even the disclosure he provided is all lies, and I provide the court with good evidence. And the last I put motion to, and the justice, what his like feedback, he said that the respondent has credibility issues. And he's lying and he's not going to be believed, right? That's what he said. So now, as you're telling me that it's not, but the judge said that my lawyer said, but the accident happened before, and all the documents belong to the medical issue, and it's confidential. But the justice say, still, we would like to know if there is tort, So I don't know what's going to happen after I provide evidence that I'm not taking any money, only the income replacement, and I send all the checks, and I'm not hiding anything, because in this case you don't have to hide anything, because in the end they will discover that and you will be in trouble. Be honest from the beginning until the end of the case, you will win. This is my belief, right? So this is for the thank you. Now you told me something, I'm gonna like just address it to my lawyer and say, hey, you should like give a firm answer that I didn't get any settlement. Even as you said, even if I get anything, it has to be excluded, like, from the property, as you mentioned. Anyway, I'm going to explain to her. The second things, because I don't want to waste your time. The second things is, we've been married since 1994. Okay, and I lived in the parents' home for 10 years when we get married, because they are senior, and I decided, actually not him, I decided to live with them because we can help them, because I'm I'm really kind to people, right? So I said, no, I don't want to live by myself. I want to live with your parents so I can help them and take care of them as they are senior. So during our marriage, after actually I married in 1994, in 1998, his father passed away. His mom passed away in 2006, and now he said to the court that I have no, I don't, I'm not entitled to earn anything from these properties because he inherited from his parents, and I'm not allowed to take
Mona,
any.
is this a house that you guys are living in as a
Actually,
matrimonial
no,
home?
this is far from the Matrimonial home. Matrimonial home is okay. This is from Syria assets, right? And
Oh,
what I did to prove to the court that he's like, he actually is very complicated. He sent a lot of false information. And before I was like, I'm sorry, I was like, what I have to do? Oh my God, I get confused, I get down because I'm not familiar to this. I don't know, but now I'm superhero. I know what I have to do. I know what I. So when I received something from them, I didn't look what he wrote. I look for what lies he brought, and I called my lawyer in Syria, and I called my contact in Syria, and told and asked them for 1, 2, 3, 4 evidence signed by the Ministry of Justice and signed from the Ministry of Virgin Affairs to be officially legally, right? And I received them, and the court take it as consideration. They took it as consideration, but he's still saying that I'm not entitled because he inherited this. But now, as I hear you guys, you said it doesn't matter because, first of all, I lived in this house for 10 years before I immigrated to Canada, because we immigrated to Canada in 1994. We
Mon-
get married in 1984.
Mona, that's not exactly what we're saying, though. I do have a bit of bad news there with the Syrian property. That's because it was a matrimonial home before, but if it was not the matrimonial home as of the date of separation, Anisa, right? Wouldn't it be, if it's no, so you can have, it might have been a matrimonial home at some point, but if it wasn't the matrimonial home as of the date of separation, well, I'm really sorry, you may not get the additional protection that Anisa was talking about.
It might not
Oh,
apply, but you know what it is, Mona, is that, you do have a burden of proof that you have to provide. If the respondent is providing a lot of lies on his documents or misrepresenting a lot of it, you're doing the right thing by getting the best evidence that you can, which is important. But yeah, Angela's right. If it wasn't the matrimonial home at the time of separation, you mentioned that it's far from the matrimonial home. Is it your excluded property? Maybe not. Maybe
It's
not.
his, it's
Yeah.
his, it's his
yeah,
excluded
but
property.
sorry to interrupt. But in 1991, before his father passed away and mom passed away, before he inherited this part, he put a suitcase in the court that against his father that he is entitled for part of this property, which we built a pharmacy and we built a basement apartment, and the fund was from me. Okay, so this additional part he took in 1991, even before we built it. He won a suitcase, like I don't know what it's called,
Yeah.
against his father, and he owned by he's the only owner for this part.
Okay.
So maybe the judge, the way he see it, that maybe I'm not entitled for the whole property, but I'm entitled of the 50% of the additional one.
Absolutely, because one is actually property that he owned. It's not an inheritance. Yeah, you're right, Mona, because if there was a lawsuit in 1991 where he won a case, say, and that property is his, then you're entitled to the increase in value throughout your marriage. And if it's just a portion, just as Anisa said, you would have the burden of proving what portion is you guys's versus the one that was just inherited. So yeah, so maybe what your lawyer needs to do is just to make it clear that you're not contesting that some portion of this property is an inheritance, but here is the proof of a lawsuit that shows that he owned this property, was declared to be his free and clear, and yes, you will be successful. That would not be excluded.
Yeah, but if I get evidence that I was living for 10 years, I was sharing the expenses, I was sharing the renovation in the huge, I'm not talking about the additional part, you know. I don't know if I can get something from, like, the judge is gonna say, okay, you are entitled or not, because I have evidence shows like how much I support during my marriage in Syria for 10 years before we came to Canada from 1984 to 1994. You know, I don't know. Anyway, but the last question, and thank you so very much if I was too much on you guys. You are amazing, and I like kind people, you know. So just a lot of things I would like to say that for the additional one, I got from the court, you know, all the file from 1991 shows like he won this case, you know, like I have a very strong evidence, and that's why I have two case conference and I have one motion hearing, and I believe, let's say 80% was I was the winner in these cases. And my lawyer said, I think now we have a vision where we are going, because we have different judges. In the beginning, I have judge follow like until like 2 years so far. And he was like, no, from A to Z about the case. And then we were afraid that the new judge, which is not aware about all the details, he's not talking about the order, the previous judge's order, again, the respondent, and he didn't commit to the order. And then, of course, he lost. And the judge, the motion judge said, no, you have to do 1, 2, 3. He has to pay me 50%, because since 2015 until now, I'm paying the mortgage, I'm paying the property tax, I'm paying the maintenance. He didn't pay a penny for that, okay? So he said, no, you have to give her 50%. So now the result of, she said, as long the motion justice also agreed and said he has credibility issue, meaning now the trial judge, if we go to trial, he's gonna see the same thing, because he's gonna read the report he provided from the previous justice, right or not?
A hard one to answer, Mona, because now what it is that I mean, it's off topic for our purpose today, but it's something that is dealing with the judges and what they're ordering and what they're endorsing.
Well, and it might not even, doesn't even sound like it's an endorsement that Munir is talking about, though. It's his comments, right? If it's just things he said, that's not in the endorsement, the other judges.
No, he sent endorsement. He said
Okay.
endorsement, and he sent order, endorsement and order, endorsement and order. No, we have endorsement from both judges. We have endorsement, and the second one clearly said the respondent has credibility issues.
Mhm.
And he's lying, and he's not going to be believed in the future.
Okay. Anisa, do you have anything to add to that? I mean, sounds like that sounds good for Mona, no?
Thank you so very much. I hope so. I hope so. I hope so. Thank you so very much. I appreciate, and I'm always follow. I'm always joining you guys, and I would like to thank you so much, Angela, and also a big hug to Anisa, because I follow her more than you, actually, several times. Not because you weren't, actually, not because I missed you, just because she's mostly always available. And thank you so very much. I appreciate your help and assistance.
My pleasure, Mona. I'm glad we were able to help. All right, guys. So thanks, everyone. Anisa?
Thank you guys all so much. I see a comment as well. Thank you for all the info. Thank you so much, Catherine, for your comment. Thanks everyone for joining us. If you guys have some topics that you do want us to explore in webinars, let us know. Feel free to send us some emails, some comments. You know, I'm going to put the email address in the chat, and let us know what you want to hear. I mean, obviously, if you do have specific questions, consult with us. We do have those options. We have different type of consultation timings as well. If you just need us for 20 minutes, an hour, so forth, some independent legal advice. But for future webinars, you know, we're looking to hearing back from you. Yes. All right, have a great day, everyone.
Yeah, thanks, everyone.
It's admin at y-canada.ca.com.
Yeah. Thanks so much, everyone, for joining us.
Thank you. Have a wonderful day. Bye-bye. Bye.